Hello, everybody. This is attorney Jesus Martinez, and today I want to talk to you about what is the individual hearing in immigration court really like. I know a lot of people have questions, have concerns. What is the trial, which is called in immigration court, the individual hearing actually like? Once you get to that point, that's when all the documents have been submitted, the exhibits, the evidence, the documents supporting your case. Most of the work up until that point has already been done if you have a good attorney. Once you're there in court, you have the judge sitting behind his podium. If you have an interpreter, the interpreter's sitting behind their little podium. You have opposing counsel, which is ICE, on their table. You and your attorney are sitting on your table, and anyone that you want present in the court for moral support, if they're going to be testifying on your behalf, they're in the stands. In the beginning, the judge will verify preliminary matters, if there's anything that needs to be submitted, if there's anything that needs to be edited, things of that sort. That'll get resolved there. If there needs to be some sort of motion, that will all be resolved there. Once the preliminary matters are settled, the administrative task, that's when the actual trial will begin. In immigration court, there is no jury. It comes down to basically, as I stated, you and your attorney, the ICE attorney, the judge, and if it applies, the interpreter. There is no other individuals there. If you want other people present there, they can be there. However, if you want to make it private, and you don't want other individuals there, that's also possible. Once the trial begins, you will take the stand. You will be giving your testimony as to what actually happened. The way this will take place is that your attorney, if they're a good attorney, they will have prepped you in the beginning. You will be aware of what's going to go on. Once you're there, they will ask you questions to get facts to support what it is you're applying for. If you're applying for cancellation of removal, then your attorney should be asking you questions to support that claim. Granted, those specific questions won't be right off the bat. It's going to work up to that point. They're first going to begin asking you questions. What is your name? Where are you from? Things like that. Who are you married to? Just so that it lays a sort of foundation for the other fact. Once that foundation is laid, once those building blocks of those facts are laid, we now know who you are, where you live, where you're from, what you do for a living, how long you've been in the US, things like that. Then it'll get more to the meaty questions. So if you're applying for cancellation of removal, the difficulties that your spouse would experience if you were to relocate back to your country of origin, or the difficulties your spouse would suffer if he or she were to accompany you back to your home country. If it's some other sort of immigration relief, then they will ask you facts to support that basis. Keep in mind, although your attorney is asking you questions first, the immigration judge, whenever they want, they can interrupt, they can step in, and they can ask you questions. They can ask you clarifying questions. They can take the line of questioning down another route. The judge has a bit more leeway in that. In other types of courts, this would not apply, but in immigration court, the judge can ask you questions. Your attorney can then continue with his line of questioning. He can ask you other questions to maybe clarify what the judge stated, to counterbalance the questions of the judge. It really depends upon what exactly happens there. Once your attorney is done with their questions, then ICE attorney, the ICE counsel, they have the opportunity to begin asking you questions. And what they are going to ask you really depends upon your case. Generally, they do have a certain lines of questions that they ask you. Why can't you go to your country? Generally things like, do you have family in your country? Do you speak the language in your country? Although you were harmed, or although it might be dangerous in this place, can't you go to this other place and live safely? Basically, any question that would take away, that would attack what you're claiming, they can potentially ask. If your attorney reserves, if your attorney asks the judge for time to ask questions that counter the questions that the ICE attorney asks, once ICE attorney is done, then your attorney can ask questions. Again, when the ICE attorney is asking questions, the immigration judge can also ask further questions. They can ask the questions that they see fit. At that point, once ICE attorney is done with the questions, then that's when the judge will begin making his determination on the case. He or she may state that they need more time to decide it. They may state their analysis of the case before making their decision, but after testimony is taken, then that's when the judge will make their determination. In addition, if you have any witnesses that are also going to testify in court, once you're done testifying, then that's when they would have the opportunity to testify in court. That said, once all testimony is done, the judge is going to make their determination. If you're applying for something and the judge grants what it is you're applying for, then you would get that relief. That said, the ICE attorney can appeal that decision. In addition, if you were to lose or if you were to win some sort of benefit, but it's not the benefit that you want another benefit that provides you more benefits, then you could also appeal even though you lost in some ways. In either case, ICE attorney or your attorney can appeal the case depending upon the verdict. If you found this video informative, please let me know in the comments below. Thank you. God bless.